Facebook co-founder Mark Zuckerberg says the new movie The Social Network is fiction, but he can't say the same about the legal battles depicted in it. An ongoing lawsuit brought by twins Tyler and Cameron Winklevoss claims they had the original idea for Facebook with a website called Harvard Connect.
You must really hate the Winklevosses.
I don't hate anybody. The Winklevi aren't suing me for intellectual property theft. They are suing me because for the first time in their lives, things didn't work out the way they were supposed to for them.
Joining me now, criminal defense attorney and former federal prosecutor Jay Fahey, also defense attorney Jonna Spilbor, and with a good morning to the two of you. This is so interesting, all this, because it brings up all these questions about what is an idea, what is actionable, all this intellectual property. And let's talk about the twins, Jonna, because they did settle. They got like $65 million when they brought the first suit against Mark Zuckerberg. What are the grounds for another one?
And that's not chump change. Well, now their story is that Zuckerberg undervalued the company when they agreed to settle, and the only way that lawsuit will fly is if there were some fraud involved on Zuckerberg's part. Without that, they already had their bite at the apple. They don't get another one.
Do you mean to tell me that you're going to have a whole court case like this with $65 million, the outcome based on what Mark Zuckerberg, okay, let's see, I think my company's worth like $1 billion. You mean there's not a bunch of people that are going to be checking all that and figuring that out and analyzing it and bringing that to court?
Yeah, that's ridiculous. What happened when they settled this? $65 million is an awful lot of money. So both sides had very sophisticated lawyers, I'm sure. They went through this, and when they signed the releases, my guess is they were airtight. To prove fraud is very, very difficult. But I agree with Jonna. They'd have to show fraud and intentional fraud. Right now, the case, they're trying to reopen that settlement. The judge said no. It's on appeal. I agree with Jonna. It's a very much an uphill battle.
They think they got a bad deal because the company's worth
they only got $65 million. Okay, but how do you prove something is an idea? It is your property, and someone else developed it, so they stole it from you. I mean, isn't brainstorming and discussions between these guys who all admittedly worked together for a while? I mean, isn't that part of it?
In this case, there were emails that went back when they were at Harvard as to what they wanted to do together, and the sense I got is that they kind of agreed to set up a social network system. They didn't use this particular name, but the basic idea may have came from the entire group. It wasn't just one.
They must have done so. They had some rights, or else you're not going to write a $65 million check just because you want to make somebody go away. So they probably were able to prove something, but just because they were part of the process doesn't mean that they should own the process. So I don't. Now what they want is $500 million, and they're not
$500 million.
Well, I don't know what they're going to want more than what they got, and simply without somebody lying, without all the experts lying, without all the attorneys lying, I don't think they can reopen this.
Okay, you're talking about this. Common sense might dictate what we're saying is true. So then, Jay, where is the lawfulness in bringing forth a suit like this? Or is it one of those kinds of suits that they're saying, we're just going to put this out there, we're going to try and get the money we can, and we're not going to get this thing into court?
I have a suspicion it's more the former, as you discussed. There's an awful lot of money in Facebook. I think that they think that looking back, $65 million was not enough, even though it's an enormous amount of money, and they think they're entitled to more. It's that simple. And the suit may have real value or it may have nuisance value. But again, once you have a settlement, within a range, it's basically over.
How much might this, Jonna, help to better define intellectual property? Because that seems a rather nebulous area at this point.
Intellectual property law is so complex. I don't think it'll better define it. What I do think is the next time somebody has a big idea, you really need to have people sign confidentiality agreements. You really need to dot your I's and cross your T's while you're getting from point A to point B to best protect yourself.
That's going to do a heck of a lot of the brainstorming process.
It's very difficult because oftentimes you brainstorm with something. Wouldn't this be a great idea to do this, and this, and maybe 99 times out of 100, it'll never work.
Doesn't go anywhere.
But when it goes somewhere, it's almost too late then to go back to the paper.
Jay and I brainstormed over Starbucks in between segments. I have some wonderful ideas that he's going to steal.
Yes, I am.
You heard it here first. We'll come fight about it.
I didn't send her any emails.
Okay. All right, cover your tracks. Can't both of you. Okay, Jonna Spilbor, Jay Fahey. Thanks, guys.